Hello and welcome to this webinar, which is hosted by the UCL Autonomous Shipping Project. I'm Dr Melis Ozdel, the project leader.
And I'm Olivia Tolson, project editor.
Today, in the third of a series of interviews with experts in the fields of autonomous shipping and artificial intelligence, we will be speaking with Felix Collin, doctoral candidate at the University of Turku. The other interviews in the series can be viewed on the UCL Law YouTube channel or through the UCL Autonomous Shipping website, which is linked in the description box of this video. We are looking forward to speaking with Felix today. He is a member of the Baltic Area Legal Studies Steering Group and the Algorithmic Agencies and Law Research Project. He recently contributed to the book Autonomous Ships and the Law. Many thanks, Felix, for joining us today. Could you please tell us your background in autonomous shipping?
Yes, and first of all, thanks for inviting me. It's completely my pleasure to be here. My background to autonomous shipping basically began in several years ago, and it was basically someone could say that it was somewhat a happy coincidence that it happened. I was thinking about making a doctoral thesis, and I had a discussion with one of our professors whether there would be something where I could be useful, and it appeared that there actually was something. Our university was going to be involved in a project called AVA, which comes from the words Advanced Autonomous Waterborne Applications, which was one of the first research projects on this topic ever in the world, led by Rolls-Royce. And when that opportunity came to me, I decided that sounds interesting, because I had always been interested in law and technology, and that was basically it. So I went into that project, and at first I was mainly looking into product liability side of things related to autonomous shipping, but when time went by, I realized that I was more and more interested about ship owners' liability as well, and also some more, can I say, more general questions related to conceptual issues. What are we talking about when we talk about unmanned ships and autonomous ships, and what's the difference, and so on, and how we should think about those things. And that's basically which led me to write also something on those topics as well. So basically, that's how I ended up here.
So you argue in your chapter, because obviously you have written a lot of things, in your chapter in Autonomous Ships and the Law, you argue that the main concern regarding autonomous ships is not their level of autonomy, but their level of manning. Why is this?
Yeah, this basically originates quite far back, because in the early days of discussions, it was very common practice to divide these new ship types into two main categories. There was remotely controlled ships and there was autonomous ships. And because people tend to think that, okay, it's so that the remotely controlled ships do not necessarily change so much, because there is still a human, and when we can't blame that human. And we can say that there is a human that must follow the same rules as the onboard crew would have to. So people tended to think that it's just autonomous ships that are extremely complicated in legal sense. To some extent, that's obviously true, but for me, the problem was always that if we think about remotely controlled ships, there's actually a couple of problems, but the main and most obvious problem is obviously that they are remotely controlled only as far as there is a remote connection available. So immediately when we lose that, those remotely controlled vessels actually become autonomous vessels. Even if it's so that that's quite rare when that happens, that triggers many of those exactly same questions that we have in respect to autonomous ships. So in that sense, I thought that it would be more important to first define the level of manning and then discuss about about the level of autonomy. And it's not just about losing this remote connection, because it's also so that in a manned ship, even if you are relying quite a lot in technical equipment, even in that case, obviously, the difference is that if you don't have a crew on board, there's no one who could put his head or her head out of the window and see what is going on. So it creates a new layer of risk where you actually need to rely on technical equipment more than ever before, meaning that also creates that kind of risk that we are not so used to in traditional shipping. And if we think about, it's not necessarily so that, as far as I have understood, that we would necessarily be taking the whole crew away from the ship. We may also operate with a limited crew when, for example, that they are not working full hours, but only ordinary office hours, and when they are sleeping, that those ships can be remotely controlled and monitored. So it creates much more flexibility if you have someone on board, and then you can follow those rules pretty much in the same way as we have done this far. But if you take the crew completely away, then it comes always somewhat a problem, regardless of whether the level of autonomy. So in that sense, I would prefer, and that's also why in my article it's titled Unmanned Ships and not Autonomous Ships, because I think that even if many things relate to autonomy, it's not just that, and we should first define the level of manning.
Obviously, much will therefore change depending on the level of autonomy, of manning, and that is obviously something that's going to change quite a lot. But in general terms, what do you think should be the basis of ship owners' liability?
That's a good question, and I think that to answer that, we have to first somewhat think about what is actually the problem in ship owners' liability. And well, the basic problem is quite easy, obviously, to understand, that there's rules which require that we have to have someone who has acted negligently, and if we don't have those persons anymore who can act negligently, or that we cannot for some reason blame anyone, then we have a problem. So that's obviously the case which we are discussing about here. But what kind of rules or basis of liability we should have? There are different ways to approach these things. In one way, we can, of course, think about that who can control these risks first, and this is often so that people say that it's the producer of this technical equipment that can control many of these risks, and that could mean that perhaps there would be no need to impose strict liability for ship owners. We could just say that, okay, there's some producer who should be liable. But on the other hand, it's also so that we also should be thinking about why and who is benefiting that we use autonomous or unmanned ships, and why they are using these new types of ships. What I mean by this is that if we think about who would be operating an unmanned ship, it's most likely a commercial activity then. And the basic idea of commercial activity, as far as I have understood it, is to make as much money as possible, or at least in many cases it's like that. So if we think that the main incentive to operate vessels without having a crew on board or without active monitoring, especially, is to reduce crewing costs, and therefore make it more beneficial in economic terms, I think that would mean that we should really think about putting ship owners strictly liable. then on these new risks that appear due to this fact. But this is something that is quite complicated also, that it's quite often said that one reason why these new technologies are even developed is that they can also increase safety. And this is one point where I also come back to the distinction of autonomous ships and unmanned ships, because I think that quite often the safety benefits could actually be achieved also by just putting those exactly same technical equipment on board a manned ship and help crew with that. So I'm not sure if we think about the safety, that is it so that it would so much help that we take the crew away from there. It's mainly that there's no one on board that can die anymore. But taking that crew also creates new risks, and I think that's one point that also supports the idea that it could be strict liability, in the sense that it's not necessarily the safety that requires us to take the manning to a lower level. It's more like economic reasons most likely. So to answer, some form of strict liability, in my view, would most likely make sense. But at the same time, I also have to stress out that it's not a question that there is a clear-cut answer that would be always correct, because jurisdictional differences are quite significant. So in some jurisdictions where there is a very long tradition of fault liability and strict liability has been applied only very, very rare cases, that kind of idea that we would put the general strict liability regime in place, that might sound quite strange for them.
So in what circumstances should ship owners be allowed to avoid liability for accidents caused by autonomous ships?
Yeah, that's a pretty tricky question in my view, because there are different kind of risks that we have to be discussing about. The first thing is that what I think we should pay attention to is that we should first ask whether it really matters whether the ship is autonomous or whether the ship is manned or unmanned, because there are some obvious risks that has nothing to do with those things. For example, natural disasters. If something like that happens, it's quite obvious that if we say that ship owners should not be liable for those kind of things with manned ships, then it's quite likely that we should say the same for unmanned ships or autonomous ships as well. But the tricky part is those risks which are kind of new. For example, if we think about cyber attacks, what should we do with those? Because we are then discussing such risks that, well, basically we are often decided to do so that if a third party causes a loss by his own intention, that he has intentionally caused harm to someone else, then we have quite often excluded liability, for example, from ship owners. And we do the same with cyber attacks as well. That's a quite tricky question, because those risks, at least to some extent, are that kind that they perhaps do not exist in the same way with manned ships as they do exist with unmanned ships. So they are somewhat more complicated one. And another thing is also collision liability, because there's obviously at the moment those based on the concept of fault, and even if we say that okay, we would have some sort of general strict liability regime in place, we probably still have to have some sort of liability allocation mechanism in those cases when we have two ships colliding with each other. So what would that be? That's also a good question, and I think that that's really a question where there's really no correct answer either, because if we think about, for example, how this same thing is dealt in road traffic in different countries, there are very different approaches to it. So they are, but that's something that should be considered. But then again, I would also like to say that we should think that should we really even have different kind of rules to manned ships and unmanned ships? Is it more like so that we should just have one common strict liability regime in place with certain exceptions, and that's it? So basically just, for example, say that all technical failures would always cause liability or something like that. So that's also something, and personally I think that could make more sense, because there is also so that it's not just that we would have manned ships and unmanned ships, we have also periodically unmanned ships, and we have a different kind of autonomy in place, so it could become quite complicated system if we would do that. So that's one point to consider as well.
What about product liability? Do you think that will have a role to play in shaping the liability regime for autonomous shipping?
Theoretically, probably yes, but in practice, I'm not so sure about what it will do, because one thing is obvious that even if I say that ship owners should be strictly liable for losses, at least in some form, that in my view doesn't mean that we would exclude the possibility to make claims also under the product liability rules. It's more like vice versa, that it's quite obvious that they're still available. Also, if it's a technical failure that we can trace back to the manufacturer, why not also put that person liable? The other thing is that if I approach this thing, for example, from the EU perspective and the EU Product Liability Directive, the obvious problem there is that its applicability is actually quite limited. So there are losses that are caused to property that are used in commercial activities are excluded completely outside the directive, and that obviously causes quite a lot of problems in shipping, because that's exactly the most important part of losses that we are dealing with. So at least at the moment, if we just would be, if the only alternative to make claims against the vessel manufacturers and component manufacturers would be fault liability, then I think that the role would be quite limited, no matter what we do. The other thing is that even if we would have a possibility to make claims against vessel manufacturers, we also have to remember that the agreed parties would most likely make claims against that person which would be most easiest one to make claims against. And if we have a strict liability regime in place in ship owners' liability, with probably with a liability insurance as well, I see quite little reasons or no reasons why anyone would make claims against the producer of the vessel or component in those cases, which basically means that it would only be a recourse in that sense, and then it would basically be a contractual issue, that how do we want to contractually allocate these liabilities in the end. And if we think about that, that's also quite complicated question, and I think that's related also to the position of insurers, that what kind of liability allocation is even possible to have, because if the reality is that producers cannot have a good insurance policy against those risks, then that kind of liability allocation where the producer would pay would probably be a dead end. So so I think in that sense, I would say that product liability is a possibility, but quite a lot should be changed in that sense, that it would really mean much. Unless, of course, that we decide that we do not change the rules of ship owners' liability in any way, then it might be a bit of a different story. But one thing, however, I have to mention, and that is that under the EU Product Liability Directive, it seems to be that the rules of limitation of liability would not apply, which is quite a challenge in maritime context, as some other cases have shown us, that if we can try to get better compensation by making claims under the product liability rules, then obviously that might be a possibility. But even then, if that would happen, I would then ask that, is it really so that we would decide that product liability is then the answer, or would it be more like that we have to do something for the rules of limitation of liability, or what we should do? So even then there would be different alternatives how to move forward.
Many thanks, Felix, for this very interesting interview and for sharing your valuable knowledge and thoughts in autonomous shipping, and particularly your thoughts about the allocation of liability and how the insurance arrangements need to be made. These are really important, but quite tricky and challenging issues. So you raised really, really interesting issues in this interview. So we're grateful for your time. And we very much look forward to your future publications on autonomous shipping and artificial intelligence. Thank you very much, Felix.
Thanks for having me.